Hi, Amber Cohen here, trial attorney, and I love to watch trials. All right, so we're getting right back into it with the Kouri Richins trial. I am very excited, first of all, because I have 25 subscribers, and so I would like to just thank my family because they're supporting me, well, and my inner circle. And I understand that I need this for the YouTube love. So thank you. And if you do like what you hear or what you see, if you could like, subscribe, comment, let me know what you're thinking. And I really appreciate, hopefully, all good stuff. All right. So Kouri Richins, day 6. The evidence gets organized. Today was what we call a layering day. Not too many fireworks, no theatrics, just the state methodically tightening its bolts and getting in the evidence that the state needs for the conviction. This is exactly what we're talking about and why her legal lens is what we're here to do, which is analyze, because it's not about the drama. It was really about structure today. So it wasn't loud. It was strategic. Ultimately, the day stopped arguing and there was organizing. So what I mean by that, we saw supplemental toxicology report from Dr. Christensen. We saw some rebuttal testimony with respect to Robbie and introduction of financial motivation, intertwined with a little mistrial argument, a little defense cross at the end, which I think, was good. So this is where I think the cases are really starting to crystallize. The arguments are really starting to come together about what everyone is going to be closing with. However, let's start with the witnesses first. So Dr. Christensen, he's the medical examiner. It looks like he performed, or at least he had a discussion about a supplemental fentanyl test. They did a toxicology report that ultimately was recorded in writing with the supplemental report. But Kouri Richins, from what I gather, had a phone call and spoke directly to Dr. Christensen about the supplemental testing report. So it was definitely investigatory type testing. And what it did was help the state to strengthen causation. And obviously it narrows the alternate explanation as to accidental, those types of potential reasonable doubts. And what we didn't know, or I didn't know, we had a recorded phone call. They recorded the phone call when Kouri Richins calls Dr. Christensen. And I guess the real legal question is, was that consciousness of guilt? Or is that a spouse trying to understand what happened? She gets the report and she has some questions. Here, I'm not going to make that decision. Obviously, that's what the jury is deciding. So I do think it's important to note she's not running away. She's engaging. She had some questions. I thought the questions were actually, intuitive, but it can't cut both ways, right? The jurors are watching her tone, not just her words, and trying to figure out what's going on. Then we saw a video of Robbie Crozier, poor Robbie, and that was when he was in lockup. I think he testified yesterday, something about how he was, coming down off of his drug addiction. So I think it was a couple days later. The officers definitely go in. They tell him, hey, listen, we know you sold these drugs. We don't even really need you for that, basically. But, oh, by the way, just tell us what's going on. The judge did allow, by the way, the defense objected. They didn't want it in. The state got it in. I keep saying Commonwealth. I'm so used to Massachusetts. But the state allowed the evidence in, the judge did, as direct rebuttal evidence. And what the judge instructed the jury to say was basically, you can't listen to what the officers are saying, but listen to what Robbie is saying as it directly, what the state is saying, rebuts what he told the state on Friday. So the detectives questioned Crozier about the transactions with CL, and notably, he did appear to have a better memory with the interview. the detectives referenced possible fentanyl charges. I think, that could also sway a jury when you start to see the detectives putting some pressure on a witness, especially when the witness says, hey, I didn't really have a memory and I was coming down off a, drug addiction. And basically threatening him with federal fentanyl charges, trafficking, etc., if he didn't cooperate. Because they did keep to say, we don't really need you. We're just asking you questions. We just want you to fill in some gaps. Well, of course, they need him. That's why they asked him questions. But that's beside the point, because he answered the questions. Now, it did show that he did state he sold the blues. So that was clear. His memory certainly did seem to be better at the time. But the question is whether or not was it inconsistent with his trial testimony. I think it's debatable. Obviously, that's what the jury gets to decide. The state got in what it needed, though. And I think that was his testimony was much clearer. It was direct. He answered the officer's questions. And that is really what the state needed in order to, again, lace this theory of the overdose. And he's the source of the drugs. They needed him. Transaction acknowledgement is, where we ask whether or not the changes in this credibility, or did this simply reinforce what was already admitted? Pressure affects memory, right? So being in the jail cell or lockup and having the federal officers or the state officers talking to you about, hey, you could be looking at some charges here. You better help us. So, of course, that might have inspired him to be more fruitful at the time of that original investigation. But again, the credibility ultimately comes down to the jury. It doesn't automatically create inconsistency. So that is something the jury gets to take into play, whether all, none, or some should be considered from Robbie. There you go. The next witness was Allison Wright. Now, Allison Wright, I think she said met Mr. Richins in junior high. And she introduces really what the state is going to be showing as motive and ultimately financial concern. So the defense asks for a voir dire, which in essence, we excuse the jury. We start to ask the witness some questions to make sure that we know what the witness is going to testify to and not necessarily have an issue where it's in front of the jury causing potentially a mistrial or some sort. So the defense makes an objection, asks for a voir dire, the judge allows it. She basically says she has a conversation that occurred 3 years before Eric's death, and defense argues it's too attenuated. In that conversation with Kouri, let me back up, with Kouri, Allison says that they talked about the prenuptial agreement, marital discord, some issues, sourcing, financial motive. The defense argues that it's more prejudicial than probative, and the judge overrules that argument, says, nope, it's relevant. It absolutely, there's no question in my mind. It shows concerns about the financing, and it obviously demonstrates steps taken to mitigate the potential financial loss. There was some other discussion in there, but it's not substantially outweighed by the unfair prejudice. And translation, motive evidence stays in. Even though it was 3 years prior, judge let it in. So she got to come back in front of the jury, basically says, hey, testified to the conversation as she did in the voir dire, and defense tries to pivot on the cross. So defense, now they get to go after bias and credibility. Defense is throwing out, affair implications, undermining the context, saying that she is not giving a full story here, suggests she may have reason to confide into an unrelated affair. But the judge ultimately allowed the testimony in whether or not she knew about the affair. Although he did show from what appeared to me, showed some mild frustration with the state as they were objecting to that, because it's cross, and cross-examination, it's generally a broader brush, and you're allowed to go after the credibility of the witness. Bottom line, though, I believe she came in she looked very truthful. She seemed nervous. She appeared to be telling the truth. And really, again, credibility, all that matters, jury gets to decide. Ultimately, I think that was a little bit of a point for prosecution today. So the next witness was the phone extraction. Well, actually, there was a little intermission there because defense argued that they didn't get records in time. They weren't put on notice. They cite the rules. They cite a couple cases. And the judge said, "Did you get the exhibit list?" And defense says, "Yes." And the judge said, "Yeah, you got notice." So that was the really short story of it. It was a little longer than that. There's some cases cited. Either way, judge overruled the objection. Documents are in. But the nuanced moment that I thought was interesting is that defense also got back up and said, if the state wants the extraction data argued, even though the extraction report was not itself admitted into evidence, that the extraction itself should be admitted. And she said, defense counsel said, "I'm okay with that as long as if I get to put my expert on the stand to do the same thing, which is discuss the extraction, but even though the full extraction is not admitted." And the reason why you don't want the full extraction fully admitted is it's just got way too much stuff. Not necessary for trial, and it's a lot faster. But extraction is different than the data set. The data set is the raw data. And, the judge said, "Hey, as long as you lay the foundation, then I have really no issue with what you're talking about. But you're going to have to lay the foundation." And remember, extraction is different than a data set. Chain of custody matters. The metadata context matters. So the guts of the phone are really what does not equal the summary of the report. The judge declined to require that. So this is just, again, another procedural match, a little bit of a chess game, and the defense is really setting it up so that she gets to put her expert on, gets to have that expert testify to just pieces of that extraction without having to have it all go in, which I think was ultimately a win for her. And also the state ended up getting to put their evidence in. Now, we did see the defense lay the mistrial record. There was a motion for mistrial, and it was, as we suspected, the jail call. And there was an issue. One of the witnesses on Friday said basically that there was a jail call, and custody status being revealed to a jury is very prejudicial. Whether they may think she's in jail or not, you're really not supposed to talk about that. Defense makes the record in order to obviously get that down in case there is a conviction, that they can come back and point to that as being an error of law. Trial courts really do have broad discretion in whether or not deciding if that was in fact enough for a mistrial. But jurors know that jail calls exist. Jurors are not potted plants, as they say. They're aware this is a first-degree murder charge, and most likely she's in custody. So as long as he did a curative instruction, I don't believe that prejudice was substantial, or that they were able to show a substantial amount of prejudice. It's a high bar to get that mistrial. It's a lot of work. And they are rarely granted because really it detonates the fairness of the proceedings. But I don't think that happened in this case. It was a real quick mention of jail call. And so for that, the judge denied that motion for mistrial. and we moved on. So the digital forensic portion of this case, it started with Mr. Kouri, and he is the state's investigator, and he's a forensic analyst, I should say, professional, very methodical. He was, I don't know about what the other YouTube world is saying, but I found him a very likable witness. The state used him for demonstrative evidence. Again, they didn't use the full extraction. They allowed Mr. Kouri to take the information and create these maps, these location maps by cell phone data. And he really brought some life to what I would say is some pretty boring stuff. He definitely nerded out, and I found it actually kind of very educational and helpful. Now, it was communications between Richins and Lauber, Carmen. It was also communications between Carmen and Robbie. And so you'll see he showed and pointed out sort of the movement around the time of the text messages to obviously coordinate the drug deal. And text messages, he then went into web searches to show that there were some pretty, arguably questionable web searches, and there's some deleted message discussions, and God, there was a lot. Anyway, he did a lot, and he was very likable. I thought he really did a good job to show that the state wasn't really arguing. There was... they just laid it out there. It was very clear, and let the jury see the text messages, see the web searches. They put it up. It was demonstrative. It was easy for them to digest. I thought it was really helpful. But on the same side, poor Scott, he's the court IT specialist, and the judge keeps referring him to Scott. And he's absolutely earning his paycheck because they seem to have some technical issues in this courtroom. But he is really doing well under pressure. And honestly, Scott earned some kudos today. So the movement data, the visual mapping, as they call it, is tech juggling. But I think overall, this was very helpful for the jury. And this is really what we call modern day prosecution. That's what's happening. All right. So then we get to the defense. And I think I spoke about it on Friday, but the defense is really just building quietly their reasonable doubt. That is what this case is going to be on for them. Attorney Ramos, I think he was the one that handled the Kouri cross-exam. And really, he points out some pretty easy lobs, I would say. So web searches have no dates. He can't prove who conducted the web searches. And really, he hones in on context. He says, you don't really have any context, do you? You don't really know what was going on that day to day to understand why she would be searching that. I mean, sometimes a search history could really make anyone look guilty, right? I mean, we all have questions. But I thought he did a nice job with that. In other words, data doesn't equal narrative. Okay. So this is the theme that's definitely emerging from the defense, and you cannot prove certainty. That's what they're saying. You cannot prove this. And again, the bar is pretty high, beyond a reasonable doubt. So context matters. This is what they're starting to do, which is attack that reasonable doubt territory. Mr. Kouri remains steady and likable, frankly, but defense definitely planted some seeds, and he didn't fight them on it. I mean, he gave them what they asked for. And so the jury got to hear some of those nuggets. And frankly, I think it was a win for them too. So both sides got some pieces from him. Although overall, I think, ultimately prosecution got what they needed. So just to recap, day 6, it was not dramatic, very deliberate. The prosecution was tightening the structure of the case, and the defense was just quietly reinforcing the theme of reasonable doubt. Today, we saw the toxicology, Dr. Christensen, refine, I guess, the medical evidence to talk about that supplemental report and the additional fentanyl testing. We also got to hear the phone call, which, again, I thought was really interesting. And I'm really curious to hear what you guys have to say if you listen to that phone call. But I just think, it's funny because the jury's, how that's going to land with the jury. Either way, motive evidence was introduced through the family, Eric Richins' friend, Ashley, who basically said that Kouri was talking about financial problems, marital problems, prenuptial agreement way back in 2019. So I think that was a win for prosecution. And then they got in the transcript and the video of Robbie in custody when basically he told the detectives that he did sell those drugs. He had a much clearer memory. He talked about blues, M30s, talked about it all. And at the end of the day, they got that rebuttal evidence in, and I think it was helpful for them. So I think it'll be interesting to see where this all lands, because ultimately the testimony today wasn't emotional. It was building, again, the pieces they need in order to close this case. The prosecution has the burden, and we're building up towards that closing argument. I'm not sure when it's scheduled, but each piece of evidence is going to be used in the closing argument. So this was scientific reinforcement. This was laying the steps so that they get to tell the jury what they think happened. Likewise, the defense got to argue and ask and get some nuggets. You saw what the cross-exam was trying to get through. They definitely did a good job of that, which was trying to just poke holes in what the state was ultimately, what their theory is. They're trying to lay in that reasonable doubt. So jurors are evaluating the tone as much as the content. And interesting pressure dynamics when it comes to Robbie, because I'm not sure how that's going to land with the fact that the detectives said what they said with respect to, federal prosecution, fentanyl prosecution, drug trafficking, drug dealing, etc. So his memory obviously became a lot sharper. But Allison's Wright testimony was, I think, really helpful in the sense it does introduce that theory of financial motive. And, ultimately the judge believed that it was probative and the probative value, outweighed the prejudice against Ms. Richins. So the defense's objection strategy today was strong, although albeit they did not succeed. And frankly, that's not uncommon. Really, the defense at this point, in some way, they know that they may lose, but they have to lay the record in case of the conviction. So you're going to see these objections happening. You're going to see these arguments being made, and they have to make them for the conviction purpose, for appeal. So, because if they don't make those objections, she doesn't, after the conviction, get to argue it. So without those objections being made, it's not preserved for later down the line. So that's really the chess match, right? The lawyers are thinking 3 steps ahead. They've got to make sure that they're protecting the record. And that's what we saw with that mistrial motion. The mistrial motion, they knew it was going to be denied, but they went ahead and argued it anyway, made a good argument. Certainly, I would have made the argument, frankly. I'm sure that's why they went to sidebar immediately after the state's witness on Friday said, "Oh, you mean the jail calls?" And that was clearly not appropriate. And honestly, she works for the sheriff's department, I think, so she should have known better. She could have, but either way, it is what it is. So the defense, though, however, is quietly just reminding the juror the little nuggets of reasonable doubt. And I thought it was a good battlefield today. We saw some each way, but the state is definitely got this circumstantial case starting to piece together. It's looking stronger. And I'm really curious to hear what you guys think or what your takeaways were. Is it the prosecution assembling what we would say is a mosaic, or is the defense highlighting, the missing tiles? So the jury is definitely watching, and I always get curious, what is the juror thinking? You know, day 6, they're not allowed to talk to anyone. They're not allowed to go online. They really are, and jurors respect that. They absolutely respect the judge's orders. You know, occasionally you get a rogue agent here and there, but for the most part, my experience is jurors take this very seriously. Once they're sworn in, they follow their duties and they follow the orders of the judge. But, you know, the jurors are watching not just the evidence, but how it's delivered. And so it's not it's not about shock factor. It's about structure. It's starting to come, the opening statements are starting to come together for them, and structure in a trial always wins. So we'll see what happens. Thank you for joining me. And if you like what you see, please like and subscribe.